everyone. My name is Ruhee Singh, and I'm the chair of the Healthcare Law section for the Beverly Hills Bar Association. I am excited to introduce our speaker this morning, John Mills. John is a partner in the healthcare practice group at Leach Tishman in Los Angeles. He focuses on healthcare litigation and reimbursement disputes, representing hospitals, addiction treatment centers, physicians, medical groups, and pharmacies. John advises clients on managed care and reimbursement compliance, anti-kickback and Stark law issues, peer review and credentialing matters, and the federal 340B drug discount program. He's been recognized by Best Lawyers in Healthcare Law and as a Southern California super lawyer. John is a member of the American Health Lawyers Association and the California Society for Healthcare Attorneys. And now I'd like to turn it over to John to go ahead and get started. Thank you.
Thank you, Ruhee, and thank you everyone for attending. I'm excited to speak to you today about healthcare law, which has been my area of practice for pretty much my entire career. With this presentation, I get to talk about some of the kinds of cases and issues that I commonly handle in my practice and that I often litigate. I want to be clear at the outset. I've designed this presentation for the non-healthcare lawyer or the lawyer who is early in their healthcare practice. This is a very high-level presentation where I'm going to be scratching the surface of several major areas of healthcare law. The operative word in the presentation's title is brief. I hope you're not here because you're expecting a deep dive into the anti-kickback laws or HIPAA. Unfortunately, in a single hour, I simply don't have the time to deep dive into any particular topic. Rather, I will hopefully provide all of you with a sense of what healthcare law entails and help you with issue spotting. I should also point out that my entire practice is dedicated to representing healthcare providers. That means the doctors, the hospitals, the pharmacies, laboratories, everyone on the provider side of the equation. I don't represent patients, nor do I represent healthcare payers like health insurance companies. So please keep that in mind. This presentation comes from the perspective of provider side counsel. Next slide, please. So with that, I must, of course, give the obligatory disclaimer. I'm not here providing legal advice. This presentation is for informational purposes only. Next slide, please. I have broken this presentation into three broad areas. These are areas that, in my opinion, every healthcare lawyer needs to have some familiarity with. Even if they don't specialize in one of these areas, they should be able to have a working knowledge of these areas and be able to spot these issues when dealing with their clients. So my three broad areas are going to be first licensing and peer review. Then I'll talk about reimbursement. And then I'll finish with some common topics in regulatory compliance. And by the way, I'm not a transactional lawyer. I primarily litigate and I provide regulatory compliance advice. I'm mentioning this because my chosen topics tend to be more illustrative of my practice, to the exclusion of a lot of interesting topics that a healthcare transaction lawyer would probably talk about if they were giving this presentation. Next slide, please. All right, we'll start with licensing and peer review disputes. So when I tell people I'm a healthcare lawyer, they often assume that I'm a medical malpractice lawyer. And while I certainly consider medical malpractice to be an area of healthcare law, it's not an area that I frequently practice in. But I do get to regularly litigate cases where the central issue is whether a healthcare professional or healthcare entity acted within the standard of care and in compliance with the various rules and regulations applicable to their licensure. This comes up in the area of disciplinary actions brought by licensing agencies as well as hospital peer review bodies. Next slide, please. As you probably know, healthcare practitioners and healthcare entities need lots of licenses, lots of certifications and accreditations. Um, this includes everything from a medical license from the medical board to a pharmacy license from the pharmacy board to nursing board licenses, group home licenses from the Department of Social Services, et cetera, and et cetera. A provider can come under investigation by their licensing agency for a number of different reasons. Some of them I've listed on this slide. For example, a physician might come under scrutiny by the medical board if the board receives complaints from patients. Licensing boards will often get wind of complaints because there is a pending civil malpractice case, or there has been a settlement of a malpractice case. Under the law, malpractice settlements over a certain dollar amount have to be reported to the medical board. Often there will be referrals to the licensing agencies by other healthcare practitioners or other government agencies who are concerned for one reason or the other about the quality of that physician or practitioner's care. 805 reports are mandatory reports that must be submitted to the medical board by hospitals and other entities defined under the law as peer-reviewed bodies. A common scenario is if a doctor comes under investigation by a hospital for something concerning the doctor's medical practice, then that must be reported to the board if the hospital takes certain disciplinary actions against the doctor. For example, revoking their privileges or putting some sort of restrictions on their privileges. Healthcare lawyers will represent the provider in the licensing agency's investigation, which will usually include an interview and sometimes a subpoena for documents. If the agency files what's known as an accusation, the provider has the right to a defense and an administrative process that will result in an evidentiary hearing before an administrative law judge. If the provider loses before the ALJ, then the provider can challenge the decision in California Superior Court by filing a writ of administrative mandate under Code of Civil Procedure, Section 1094.5. The court can review for errors of law. It can review whether the ALJ's decision is incompatible with the substantial weight of the evidence. There's a number of issues that the court can review, although in large part, it's really acting like an appellate court would review a trial. So it's really focused on whether the weight of the evidence was simply ignored. Next slide, please. So most doctors are not employees of the hospitals they work at, but rather they are members of the hospital's medical staff. And medical staff is an independent legal entity under California law. The medical staff is a self-governing association with its own bylaws, rules, and policies. If a doctor wants to see patients at a particular hospital, then he or she must obtain clinical privileges from the hospital's medical staff. If an issue arises with a doctor on the medical staff is responsible for investigating that issue and potentially taking disciplinary action against the doctor. As I mentioned before, that might result in an 805 report to the medical board. 805, by the way, is Business and Professions Code Section 805. By law, the doctor is entitled to a peer review hearing before final disciplinary action can be taken against the doctor's privileges. Discipline could range from revoking privileges and removing the doctor from the staff to requiring the doctor to have a proctor while performing certain procedures, a whole host of different restrictions that might be imposed on the doctor's practice at the hospital. The origin of these procedural rights derives from the common law doctrine of fair procedure, which essentially states that a physician's privileges to practice at a hospital are akin to a property right that cannot be taken away without procedurally and substantively fair reasons. This is sort of a like due process, but in the private context. And this principle of fair procedure has now been codified in California in Business and Professions Code Section 809. When hospitals do take action against a physician's privileges, often what we see is that a physician will want to sue the hospital or sue the hospital medical staff and argue that the peer review process was a sham or was retaliatory or was driven by anti-competitive reasons or something along those lines. And when a physician files that kind of lawsuit, this will invariably be met with what's known as an anti-SLAPP motion, filed by the hospital or the hospital's medical staff. And the anti-SLAPP theory is that the peer review is protected activity. Now, I'm not going to get into all the anti-SLAPP is a whole separate presentation in and of itself, but just keep in mind that peer review is considered a protective activity under the anti-SLAPP. Over the years, there have been probably a dozen appellate court decisions in this area, just in the issue of applying the anti-SLAPP to peer review. It's a constantly evolving area, and the courts, they really seem to struggle with it because there's so many published opinions out there. They seem to be it's evolving over time. And then, frankly, this would be a great topic for an entire separate presentation. But I don't have time for that now. I'll just point out that the most recent decision on this issue is the 2024 case, Dignity Health versus Mounts. And in that case, the appellate court held that the medical staff communications, including a medical staff's failure to respond to a peer review inquiry from another hospital's medical staff where the doctor was seeking privileges, this was considered protected by the litigation privilege under Civil Code Section 47. So that was the defense that was being raised by the defendants through their anti-SLAPP motion. And this holding, it strengthens the ability of hospitals to defend against lawsuits alleging sham peer review. But I really don't think this is going to be the last word on the issue. I think we're going to see more activity in this area. Next slide, please. All right, let's switch gears and talk about reimbursement. Reimbursement is just another word for collections, and collecting payment in the world of healthcare is not simple. Most healthcare providers do not receive the majority of payment for their services from their patients. Most of the payment comes from health insurance, whether it's federal programs like Medicare or private commercial plans like Anthem Blue Cross or United Health, Aetna, etc. This is always an active area because nearly every healthcare provider will, at some point, have a dispute with a health plan or health payer over receiving reimbursement for their services. Next slide. Allow me to give a very high-level overview of the main reimbursement programs that I commonly encounter as a healthcare lawyer. There are a number of federally funded healthcare programs. The main one, of course, is Medicare. As you may know, Medicare covers people 65 or older, disabled people, and people with end-stage renal disease. Medicaid is also considered a federal program, although it's a hybrid federal and state program. And Medicaid covers low-income adults, pregnant women, and children. Then there is the Federal Employee Health Benefit Act for federal employees, and a couple of other big ones are the TRICARE program for the military and the VA program for veterans. At the state level, the main government-funded program is of course Medicaid, which in California is referred to as Medi-Cal. Medicaid is administered at the state level, but must follow certain federal guidelines. And it's mostly provided through managed care organizations. On the private side, there is commercial health insurance and health plans. Health insurance is basically an indemnity policy that is funded by the insurance company and is sold on the insurance marketplace directly to consumers and small employer groups. In California, it is regulated by the Department of Insurance. More common are managed care plans, which are different than traditional health insurance. Managed care is based around the concept of provider networks like PPOs and HMOs, where the provider contracts with the health plan to offer their services at a reduced cost. As the name suggests, it's all about managing care through a network of providers who are contractually aligned with the health plan with the shared goal of keeping costs down. In California, managed care is regulated by the Department of Managed Healthcare. A PPO is a managed care plan where you have the option to see doctors outside the network, but you pay a higher premium for that flexibility. And likely you're going to pay higher out-of-pocket costs when you go out of network. A HMO limits you to seeing doctors within the plan's network, and you must get referrals to specialists from primary care doctors who essentially act as gatekeepers to manage your care and keep costs down for the plan. Most Americans actually get their insurance from their employers, and employer-sponsored insurance falls within the scope of the federal ERISA law. We'll talk a little bit more about ERISA in a few minutes, but for now, let me just point out that under ERISA, we have basically two types of plans. There's fully insured plans, which is like traditional insurance in that an insurance company insures the policy and it's on the hook for paying benefits. And then we've got self-insured plans, which means the employer is funding the plan and it's on the hook to pay the benefits. Self-funded plans, which are generally large employers, they hire the insurance companies to administer claims and to provide the employer access to a network of providers. Next slide, please. Let's spend a couple of minutes on Medicare, which happens to be the largest purchaser and payer of healthcare services in the United States. Medicare has different reimbursement programs for different types of services. Part A is for hospitals and skilled nursing facilities. It follows a prospective payment system, which means that Medicare payment is based on a predetermined fixed amount. The payment for a particular service is derived from a classification system of that service. An example would be a diagnosis-related group for inpatient hospital services. Part B is for physicians and ancillary services such as medical equipment. It follows a fee schedule payment system, which means that services are reimbursed at a fixed fee as determined by federal regulation after the service has been rendered. If you've ever heard of the annual physician fee schedule, that's what this is referring to. Part C, which is known as Medicare Advantage, is a risk-bearing model where private insurance companies contract with the Medicare program to accept a certain amount of money, and then it's up to those companies to manage the care of the Medicare beneficiaries enrolled in that particular plan. And then finally, we've got Part D, which covers outpatient prescription drugs. It operates actually quite similar to Part C. An issue that comes up quite frequently in Medicare and other reimbursement programs is what happens when the provider is overpaid for their services. And this can happen for a number of reasons, including that the provider may have submitted incorrect information, or there was an administrative error at the payer's end that resulted in an overpayment. Of course, there could also be intentional fraud. I'm not really going to focus on that purposes of this discussion, but that of course is a reason for an overpayment as well. The law has long required that a provider who receives an overpayment must return the money within 60 days after identifying the overpayment. However, the underlying statute in the Medicare Act does not define what constitutes identification. And this has caused uncertainty and confusion and much litigation over the years. In 2025, the agency that administers the Medicare program, known as CMS, issued a rule stating that an overpayment has been identified when someone has actual knowledge of information that would establish an overpayment. Significantly, deliberate ignorance of the truth or falsity of that information, or acting in reckless disregard of that information also constitutes identification. In other words, if you have information suggesting that you've received an overpayment, you can't just put your head in the sand. If you would have obtained actual knowledge by looking into the issue, then you're deemed to have identified the overpayment. Under the new rule, once a provider has identified an overpayment, then they have 180 days to conduct a good faith investigation to determine the full scope of the overpayment and quantify the full amount of the overpayment. So typically, if it's some billing error, and a provider is submitting hundreds of claims, thousands of claims, and they discover that error with respect to one claim, then it's probably going to have infected all of those claims. So that's what this 180 days is for. It's for the provider to really do their due diligence, figure out how many claims were overpaid and what's the dollar amount at issue. Then the provider then has 60 days. Once they figure that out, they've got 60 days to refund the full amount to the government. And if a provider fails to comply with this rule, then that can give rise to False Claims Act liability. Now, I don't, again, have time to delve deep into the False Claims Act, but let me just briefly say for those of you who don't know what that is, it's a federal statute that's been around since like the Civil War. It applies to anybody who's contracting with the government and submitting claims to the government for payment. If you submit claims that are false, then you can be liable under this federal statute, and you can be liable to pay back triple the amount that you received in payment. And there's all sorts of other penalties, and it's you don't want a False Claims Act case being brought against you. So keep that in mind. The failure to comply with this rule, the 60-day rule, could be the basis for a False Claims Act case against you, brought by the government or brought by a whistleblower. If somebody in your organization or your client's organization understands these issues, they could if they know that you've been overpaid and you're not voluntarily repaying that back, they might turn into a whistleblower under the False Claims Act. Okay, next slide, please. All right, let's talk about commercial payer disputes. This is probably the area of healthcare law that keeps me the busiest. I get a lot of calls and a lot of emails from providers who are having trouble getting paid from commercial payers. And one of the first questions I ask, or one of the first things I need to know, is whether the dispute involves in-network claims or out-of-network claims. In-network disputes are generally more run-of-the-mill. The provider has a contract with the payer where there's an agreement as to the price for services, which are usually pretty low rates. But what the provider gets in exchange for accepting these low rates is they get patient steerage. They are marketed by the payer as being within the network, and of course, patients are encouraged to stay in network. Usually the contracts are pretty one-sided in favor of the payer, although there is a host of regulations that require certain terms to be present in the contracts to protect the provider. In-network disputes are resolved through mediation or arbitration. They rarely get into court. Where it can get really interesting is when a payer terminates the provider's contract. So I mentioned earlier that doctrine of fair procedure in the context of medical staff privileges. Well, that same doctrine of fair procedure has made its way into the world of healthcare contracting, at least on the private side, where if a plan terminates a provider, the provider can argue that they're entitled to a hearing before that contract termination goes into effect, because those contracts are so valuable, and some providers in a certain geographic area, I mean, if they're not contracted with that plan, they're out of business, essentially. So there's a well-known California Supreme Court case called Potvin, where the court said, even if the contract says it can be terminated without cause, that would be unenforceable in certain circumstances, and the payer, the plan, would have to give that provider a procedurally fair hearing based on termination that's based on substantively rational reasons. Turning to out-of-network disputes, where the provider does not have a contract with the payer. These tend to be more contentious and are usually litigated in court, sometimes in state court, sometimes in federal court. And the reason these are more contentious disputes is because the provider can essentially bill the insurance company whatever price they want. And if they don't like the amount they receive for their services, they can file a lawsuit over it and seek a jury trial. Naturally, payers don't want to pay out-of-network rates, and payers actively encourage their members to stay in network. Payers frequently come up with various initiatives to minimize the amount they pay to out-of-network providers. Payers will audit and investigate in-network providers. Payers will audit and investigate out-of-network providers very aggressively, and will go after out-of-network providers and put a stop payment on their tax ID number for really no reason at all, often, in my view at least. And they do this, I think, often to slow down just making payment and to get around certain regulatory timelines that exist for making timely payments. So it gives the payer a chance to kind of put the brakes on things and kind of look into that out-of-network provider, and maybe ultimately force that provider into some kind of negotiation where the provider is going to be accepting lower rates than what they're currently billing. Let's see, talk about ERISA for a minute. Most out-of-network disputes involve ERISA plans. Since the provider has no contract with the payer, the provider takes an assignment of benefits from the patient and submits claims as the assignee under the patient's health insurance policy. But when a dispute arises, the policy generally favors the payer, and under federal ERISA law, the plan fiduciaries, which could include the insurance companies or the self-funded employer, they're giving an enormous amount of deference in how they interpret and apply the policy. So often, as a provider side litigator, we'll often want to come up with a state law theory like implied contract or quantum merit or promissory estoppel in order to proceed in state court. On the other hand, though, if the plan terms, if you're able to get a hold of the plan, you're representing an out-of-network provider and you're able to get the plan terms, and you might find that they're actually quite favorable. And you might find that there's actually a straightforward case of the payer breaching the plan terms. And in that case, then we want to be in federal court. We'll actively sue under ERISA as an assignee of the patient, because under ERISA, if you're a prevailing plaintiff, then you do obtain attorney's fees. Whereas, of course, you're not going to get attorney's fees under a state law theory like implied contract. Let's see. Let's talk about mental health parity for a minute. So this is an area that's kept me pretty busy for the past 10 years or so, because there's so many reimbursement disputes involving mental health providers. One reason this has been a hot area is because of the development and gradual strengthening of mental health parity laws. So what is mental health parity? It's a recognition that mental health and substance use disorders are a disease of the brain. They are a health condition, not a moral condition. So these laws are designed to protect those suffering from mental health and substance use disorders from discriminatory insurance practices. It will probably come as no surprise that the insurance companies are not thrilled about paying for mental health care. And it's really largely a result of Obamacare and other initiatives that have really required mental health to be a covered service. It's a mandatory covered services. But then the insurance companies will often try to find ways to avoid paying it. And so these parity laws now have been passed to make sure that mental health is not being discriminated against by the insurance companies. Probably the most important and pervasive parity law is the Federal Mental Health Parity and Addiction Equity Act of 2008. The gist of the federal parity law is that it prohibits more restrictive limitations for mental health and substance use disorder benefits compared to medical and surgical benefits within certain categories. So, for example, outpatient services could be considered a similar classification. If an insurance company requires a pre-authorization to obtain outpatient mental health therapy, but does not require pre-authorization for physical therapy, then that would be scrutinized under the federal parity law. This then forces payers to comply with this law. They must defend and justify treatment limitations that apply solely to mental health coverage. A recent case illustrating the federal parity law in action is Allison B. versus Blue Cross. There, the policyholders sought coverage for their minor child to attend a residential care facility for behavioral health and substance abuse issues. Even though there was clinical necessity, Blue Cross denied coverage, including on the basis that the facility did not have 24-hour on-site nursing. The plaintiff alleged a violation of the parity law because Blue Cross applied stricter rules to mental health residential care than to comparable medical care. For example, Blue Cross did not require 24-hour on-site nursing at skilled nursing facilities. Based on this and other rules that Blue Cross appeared to be enforcing more strictly in the mental health context, the court allowed that lawsuit to proceed. Another important development under the federal parity law is that certain regulatory requirements promulgated by the Department of Labor and Health and Human Services in 2024. These new rules would have significantly given more teeth to the law, more enforcement teeth. But that 2024 rule has since been put on ice by the Trump administration. So we're keeping an eye on that to see whether that law will ever, or sorry, those rules will ever be given effect. They would be a huge benefit to both the patient and provider community, but the insurance company lobby was very, very strong in the situation, and the Trump administration is for the time being, is not enforcing those rules. Lastly, I should mention that California has its own version of a mental health parity law. It's been around a long time, and about 5 years ago, it was amended under Senate Bill 855 to give additional protections, particularly for treatment of substance use disorders. However, the California law is limited in its application to health plans and insurance policies that are regulated by California law. So unlike the federal parity law, they generally do not reach employer-sponsored plans, which of course is where most Americans get their health insurance. All right, next slide, please. Okay, we'll talk about regulatory compliance. This is really the bread and butter of healthcare law. As you probably already know, healthcare is an extremely regulated industry, and you cannot do a transaction in healthcare without considering the regulatory risks involved. So whether you're a litigator or a transactional lawyer in healthcare, you can't help but also be a compliance lawyer. Next slide, please. I think a good place to start is what's known as the prohibition on the corporate practice of medicine. In broad terms, the corporate practice doctrine, it's a prohibition that makes it unlawful for a layperson or a lay corporation to employ physicians to practice medicine or to otherwise interfere in medical decision-making. Of course, there are many workarounds. We have what is known as the MSO friendly PC model. So MSO stands for Management Services Organization. So what this is, and it's pretty complex, but essentially you'll have a separate entity set up to manage the physician practice, the professional corporation that's owned by a doctor. And through various complicated contracts, it can be set up that if that physician ever leaves the practice, the MSO has the ability to essentially replace that physician with a new friendly physician. And there'll be restrictions on that departing physician's ability to compete and all that. So it's sort of it's a common workaround where you've got situations with lay people, lay corporations that want to essentially run a medical practice, but they can't own it because the law does not allow a layperson to own a medical practice or to directly employ a doctor. But in structuring these arrangements, healthcare lawyers have to be very careful that the MSO is not given control over decisions that should be left to the physician. And we must make sure that not to pay the MSO too much money, especially if the MSO is involved in marketing the physician's services, because then this can look like unlawful fee splitting for generating referrals. Another workaround, a common workaround, the corporate practice doctrine is the medical foundation model. And this is one of the main ways that large nonprofit hospital systems can integrate physician practices into their system. There are certain statutory elements to creating a foundation. Broad terms, there must be a clinic operated by a nonprofit corporation. The clinic must conduct medical research and provide clinical care, and the foundation must have a staff of at least 40 physicians who are not employed by the nonprofit corp. So pretty much these days, most of the large health care systems at this point have a medical foundation that contracts with all of the doctors. And so in a lot of ways, those doctors are sort of beholden to that medical system. There's an interesting debate about whether the corporate practice doctrine is waning in California. On the one hand, there are a lot of practical and financial considerations that suggest the doctrine is antiquated. I've listed some factors here on this slide. There's health systems and large payers. They want to integrate the direct provision of professional services into their operations. There is a demand for physicians to practice more efficiently, to spend more time on patient care, which would then leave them less time for administrative and business concerns. So leave those concerns up to the business folks. And then, of course, there's private equity and venture capital that's needed to scale and compete in modern healthcare environments. And so a lot of doctors, they just need to bring in that capital to really be able to have a sustainable practice. So so based on recent legislation, though, it looks like the corporate practice doctrine isn't going away anytime soon. On January 1st of this year, 2 new California laws went into effect that established California as having the most strict corporate practice laws in the country. First, I'll talk about Senate Bill 351. It expressly applies the corporate practice of medicine doctrine or the corporate practice of medicine prohibition to private equity groups and hedge funds. It prohibits them from interfering with the professional judgment of licensed healthcare professionals or exercising certain forms of control over healthcare operations, including through the use of management service organizations. SB 351 is a reaction to a perceived unhealthy influence by private equity in buying up healthcare practices and prioritizing profits over careful professional judgment. It also, SB 351 also renders void any non-compete or non-disparagement provision in a contract involving the management of a physician practice. Notably, though, this does not prevent a non-compete where a physician sells all of their equity in their practice or the business goodwill as part of an asset sale. So healthcare transaction lawyers aren't completely freaking out over Senate Bill 351. They're still able to set up the MSO friendly PC model that I was talking about earlier. Assembly Bill 415 extends existing reporting obligations to private equity and hedge funds when they engage in certain transactions involving healthcare entities. So there are certain transactions, which I'm not going to get into the weeds on that, but certain transactions have to be reported to a new state agency known as the Office of Healthcare Affordability. This agency, it can't block the transactions, but it can conduct a market analysis review that ultimately can slow the transaction down. So this is something that if you're doing deals, healthcare deals in California, you need to be aware of this and kind of build this review into your timeline, because you're not going to necessarily be able to close as quickly as the client may want to. So they need to understand the existence of these new laws. All right, next slide, please. All right, let's talk about the anti-kickback laws. These are laws that make it a crime to knowingly and willfully solicit, receive, pay, or offer any remuneration directly or indirectly, overtly or covertly, in cash or in kind, for the purpose of inducing a patient referral. I've listed some example anti-kickback laws that regularly come up in my practice. So we've got Business and Professions Code, Section 650. This is a California a law. It specifically applies to physicians. It basically prohibits what I just read. But what's interesting about this law is it does not require insurance payment. So if the payment's coming directly from the patient, then this law could still apply. Now, it's very rare that you see that situation where the payment's coming from the patient. Usually it's insurance, but just keep that in mind that 650 does not require there to be insurance benefits at issue. On the other hand, Insurance Code Section 750 does require the payment of insurance benefits, but 750 applies to anyone. So it's not limited to referrals for services paid by insurance regulated by the Department of Insurance. It can apply to any kind of referrals. Welfare and Institutions Code Section 14107.2. This is the Medi-Cal, basically the Medi-Cal anti-kickback statute. Again, it can apply to anyone or really any kind of provider, but it's limited to referrals for services paid by Medi-Cal. Then we've got a couple of federal anti-kickback statutes. The first one, which is probably the most important anti-kickback statute, is what we call the anti-kickback statute, the AKS, 42 USC section 1320A-7B. This is primarily it's the Medicare and Medicaid anti-kickback statute. This is a very complicated law. It's got a lot of what are known as safe harbors. Safe harbors are essentially exceptions. What that means is even if your conduct violates the prohibition of the anti-kickback law, if you meet one of these statutory or regulatory safe harbors, you're essentially given a free pass. So the government over time has had to recognize that this law is so broad in its application that there's so many transactions that would fall under its tent. It would make the business of healthcare impossible. So there's probably 30 safe harbors now, but there's still a lot of enforcement of the AKS. It's one of the most heavily enforced laws in healthcare, and I've mentioned a case here at the bottom, the 2025 case, bottom of the slide, Pharmaceutical Coalition for Patient Access versus United States. And this is essentially a case that recognized how broadly interpreted the anti-kickback laws are. So in this case, the Fourth Circuit interpreted the term remuneration as any payment or consideration, even if it does not corrupt medical decision-making from the provider who's receiving the payment. And the court interpreted inducement as any remuneration that would influence the decision to purchase healthcare services or goods. In this case, the court held that a charitable patient assistance program funded by drug manufacturers would implicate the federal AKS so long as the program subsidizes the cost of drugs from the funding manufacturers, even if the program does not require the patient or the patient's referring physician to select any specific medication. I also mentioned in the slide the ECRA law. That's 18 USC section 220. This is a kickback law that applies specifically to addiction recovery providers and clinical labs. It has also very broad exposure. It applies to commercial insurance and it has much fewer safe harbors than the Medicare AKS. And it's a particularly nasty law for laboratories because historically labs would always look to AKS safe harbors to protect certain conduct. Well, now this ECRA applies to all labs, not just labs involved in addiction treatment. And law that was previously protected under the AKS, at least under the black letter of ECRA law, is not protected. So this is causing a lot of consternation and confusion in the lab industry, and we expect that over time regulations will be passed that will clarify that perhaps this law is only applicable to clinical labs when it comes to their involvement in the treatment, of testing and treatment of addiction medicine, of addiction issues. Anyhow, I'm running out of time here. So the main takeaway is that every business arrangement and transaction in healthcare should be carefully reviewed by healthcare counsel to make sure there's not a violation of the many different anti-kickback laws. And keep in mind that violations of these laws carry both civil and criminal penalties. And on top of that, a violation of the federal anti-kickback statute can also be a predicate for a False Claims Act case. And I talked earlier about what the False Claims Act case is, or False Claims Act is. All right, next slide, please. All right, let me spend a few minutes on the Stark Law. So the Stark Law generally prohibits physicians from referring patients for designated health services payable by Medicare to entities with which the physician or an immediate family member of the physician, where they have a financial relationship, unless there's a statutory or regulatory exception that applies. Designated health services include, among other things, laboratory services, imaging services, durable medical equipment, hospital services. So for example, just to kind of put this in context, if a physician has privileges at a hospital, is referring to that hospital, and enters into some sort of transaction with the hospital, maybe the physician is going to lease office space from that hospital, that lease agreement then needs to be scrutinized very carefully to make sure it doesn't violate the Stark Law. And as it turns out, there's a specific exception within Stark for leases between physicians and hospitals. So you need to look to see, well, is there an exception that applies? And if there is, you need to make sure you fit that transaction very specifically within the elements of that exception. It's very important to understand that the Stark Law operates as a strict liability statute. So intent to violate the law is not required. If a financial relationship fails to meet the requirements of an applicable Stark exception, then referrals may be prohibited, and claims that were submitted to Medicare based on those referrals may be deemed non-payable. As a result, Stark violations can trigger significant financial consequences, including repayment obligations, civil monetary penalties, and potential liability under the False Claims Act. Given that all health systems rely heavily on financial relationships with physicians who are in a position to refer patients to the hospital, Stark Law compliance is a central component of any enterprise risk management. And this is well illustrated in a recent $345 million settlement between Community Health Network in Indiana and the federal government. And there, the government alleged that the hospital's physician employment arrangements included compensation structures that were not commercially reasonable, and that allegedly took into account the volume or value of referrals being generated by those physicians. There was evidence that Community engaged in aggressive physician recruitment and retention strategies, particularly with respect to high referring specialists. The government alleged that the compensation packages exceeded typical market benchmarks. In other words, there was not fair market value for those compensation. The government concluded that communities' compensation assumptions, its productivity metrics, and all of this, the referral patterns, looked at the whole package. It simply did not align with a good faith fair market valuation analysis. So an important takeaway is that fair market value analyses should be grounded in accurate operational data and reasonable assumptions. Hospitals and health systems regularly use or employ valuation firms to conduct and prepare a fair market evaluation report, but it's up to the provider, up to that entity, to provide the valuation firm with complete and accurate information regarding physician duties, expected productivity, call coverage obligations, service line economics. All of those factors are very important, and they must be accurate. Otherwise, you're going to get because in community health, the hospital said, well, wait a minute, we got a valuation report. What we're paying these doctors was what our valuation firm said we could pay. But as it turned out, all the underlying information that the valuation firm was provided to prepare those reports was just not accurate. It wasn't, the assumptions were not realistic. Okay, next slide, please. Okay, we'll conclude here with the Health Insurance Portability and Accountability Act of 1996, better known as HIPAA. So, what is HIPAA? What does it protect? What type of information is protected by HIPAA? It's what we call patient identifying information, or we know it as PHI, patient health information or protected health information. But that's what we know in the industry. We call it PHI, and it covers, or HIPAA covers, what are known as covered entities. So covered entities are pretty much healthcare providers. I mean, it's a little more complicated than that, it's more nuanced than that, but essentially it's healthcare providers. But it also covers those providers' business associates. So anybody who's contracting with those providers and receiving that PHI is also within the scope of HIPAA. So for example, as healthcare lawyers, every time we have a new client sign an engagement agreement, we also have them sign what's called a business associate agreement. And that's an agreement that's designed to comply with HIPAA, that enables us to receive that PHI information from our clients so that we can do our jobs. But without that business associate agreement, if there was some kind of audit, not only would our clients get in trouble, but we could get in trouble as well. And how does patient information, how does it get used and disclosed under HIPAA? There's all these privacy rules, these security rules. It's all quite complicated, and I don't have time to get into it. But what I'll say is, what is the golden rule is you always have to disclose what's minimum necessary. So even if it's a protected disclosure from one provider to another provider, that provider can only give what's the minimum amount of PHI that's necessary for the other provider to do what they need to do. If there are two providers working with the same patient, the one provider can't say, oh, you know what, and here's also this person's therapy notes. Like that would be a violation of HIPAA. But if they were, two providers working on some cardiology issue, then obviously any records relating to those issues would be fair game. It would be protected. HIPAA is a law that, well, before I get into that, let me point out that enforcement under HIPAA is driven by the Health and Human Services Office for Civil Rights. If you discover a HIPAA violation, if you're a provider or a covered entity that discovers a HIPAA violation, you've got certain required reporting obligations. There's certain corrective actions that you need to take. And if you don't do all those things timely and efficiently, then you are subject to fines and possible referrals to the Department of Justice. The common enforcement issues that we see are lack of that covered entities don't have enough safeguards in place to protect PHI. They're doing silly things like transmitting PHI through non-secure channels. They're not storing it, and they're leaving the laptop in the car kind of thing, where somebody steals the car, gets the laptop, opens it up, and there's tons of patient information on the laptop. They're not giving patients adequate access to their own information, and they're disclosing information, more information than is necessary. Those are the kinds of things that we see get commonly enforced by the Office for Civil Rights. It's important to know that there is no private right of action under HIPAA. So a patient whose HIPAA rights have been violated actually can't sue directly under a HIPAA. But California has a very similar law, in fact, in a lot of ways more strict than HIPAA, known as the California Medical Information Act. It's Civil Code Section 56.10, and it does give a private right of action. So typically, if there's a HIPAA violation and a patient wants to bring a lawsuit, they're going to bring it under the CMIA. Last thing I'll say is that HIPAA is actually a really good way to segue into talking about telehealth and AI in healthcare, which I would love to be able to talk about. I don't have the time, and we would need an entire separate presentation on that. But it's really kind of quite fascinating. It's probably the main area. Telehealth and AI is absolutely the main area of innovation and transformation in healthcare. Legislators and regulators are rushing to catch up, and I think the primary challenge is ensuring that AI tools that those tools are being used to make decisions about healthcare in a way that's actively supervised by physicians and other qualified personnel. It's not much different than using it in AI in law or any other industry. You want to make sure that people are still involved and are overseeing what's being done. So with that, I've run out of time. I am happy to take a few questions. And thank you very much for listening. Okay, I'm not seeing any questions, so
Yep. So it looks like we don't have any questions. Thank you, John, for an excellent presentation, and thank you so much to our audience. Have a great day, everybody.
all right, thank you.